Welcome to Prince Shorten House. Students, पंजाब एंड हरियाणा हाई कोर्ट चंडीगढ़ ने अभी 13 अक्टूबर 2021 को एक नोटिफिकेशन दिया है, जो कि स्किल टेस्ट होने वाला हमारे स्टेनोग्राफर्स का और ड्राइवर्स की वैकेंसी थी, और उसमें आपकी क्लर्क्स की वैकेंसी थी। उन्होंने जो नोटिफिकेशन दिया है उसको एग्जैक्ट सही तरीके से पढ़िए। उसमें बताया गया है कि जब तक ये जो परमानेंट वैकेंसीज हैं इन पे सिलेक्शन नहीं हो जाता है, तब तक हरियाणा गवर्नमेंट को आदेश दिए गए हैं और कोर्ट्स को आदेश दिए गए हैं कि वो एडहॉक बेस पे या कॉन्ट्रेक्चुअल वैकेंसीज फिलअप करने के लिए कोई नोटिफिकेशन ना दें। इट मीन्स ये है कि आपका स्किल टेस्ट जो एक्सपेक्टेड डेट थी कि नवंबर के लास्ट में या दिसंबर के फर्स्ट में होने वाला है, वो होगा। आप तैयारी कीजिए और हम अपने यूट्यूब चैनल पर आपको ट्रायल पैसेज दे रहे हैं 80 वर्ड्स ए मिनट, जो आपको लिखने के बाद ट्रांसक्राइब करके सेल्फ चेक करना है। एक एक गलती आपको अपनी निकालनी है ताकि आप तैयारी कर सके, अपनी गलतियों को समाप्त करके, जिससे कि आपका स्किल टेस्ट बेस्ट होगा और आपके सिलेक्शन की उम्मीद हम करते हैं। हम आज भी एक ट्रायल पैसेज दे रहे हैं 80 वर्ड्स ए मिनट। हम स्टार्ट करते हैं। आप लोग इसको, वही तरीका है, लिख के ट्रांसक्राइब करके चेक करना है, और 2 दिन बाद हम PDF डाल देंगे, या हो सकता है अगले दिन, कल डाल दी जाए। तो आप स्टार्ट कीजिए। 80 वर्ड्स ए मिनट। बी रेडी, स्टार्ट। The learned counsel for the applicants argued that the effect of a scheme of compromise between the company and its creditors under Section 391 of the Companies Act is binding upon all class of creditors, whether they are assenting or dissenting. The purpose of a scheme under Section 391 and 392 is restructure and alteration of the old debts which were payable prior to the scheme, so as to make the debts payable in the manner and to the extent provided under the scheme, insofar as the case of JIK Industries is concerned. It has been argued that the scheme in JIK is different that sharp. The learned counsel for the appellant urged that once the scheme is sanctioned, it relates back to the date of the meeting, and in support of the said contention, reliance was placed on a judgment of the Privy Council in the case of Raghubar Dayal versus the Bank of Upper India Limited, reported in AIR 1919 PC 9. It was also urged that in a scheme under Section 491A, judgment is in rem. The learned counsel further submitted that admittedly the respondents objected to the scheme and is a dissenting creditor. The learned counsel for the respondents, on the other hand, submitted that in the petition which was filed before the magistrate on behalf of the Sharp Industries. The prayer was only for causing of the criminal proceedings and there was no prayer for compounding of the offences. While the magistrate refused to quash the said proceeding, then while challenging the same in the High Court, the prayer for compounding was made for the first time. The learned counsel for the respondents has drawn the attention of this court to the order passed by the Metropolitan Magistrate 12th Court, Bandra, Mumbai, whereby the learned magistrate passed an order on the application of the accused, the appellant, for compounding of offences under section 138. By the said order, the learned magistrate rejected the prayer for compounding made by the appellant under section 147 of the NI Act. It was also pointed out by some of the respondents that after the High Court passed the impugned order whereby the prayer for compounding by the appellants was rejected and the appellants could file a petition. Considering the aforesaid submissions of the rival parties, this court finds that the effect of approval of a scheme of compromise and arrangement under section 391 of the Companies Act is that it binds the dissenting minority, the company, as also the liquidator if the company is under winding up. Therefore, section 391 of the Companies Act gives very wide discretion to the court to approve any set of arrangement between the company and its shareholders. Learned counsel for the appellants placed reliance on the decision of this court reported in AIR 1970 SC 1041 in support of his contention that a scheme under section 391 of the Companies Act is not a mere agreement but it has a statutory force. The learned counsel also urged, relying on the said judgment, that the scheme is statutorily binding even on dissenting creditors and shareholders. The effect of the scheme is that so long as it was carried out by the company by regular payment in terms of the scheme, a creditor is bound by it and cannot maintain even a winding up petition. Even if the aforesaid position is accepted, the same does not have much effect on any criminal proceedings initiated by the respondent creditors for non-payment of debts of the company arising out of dishonor of checks. Actually, the allegation of the respondent is that even payment under the scheme has not been made. However, without going into those factual controversies, the legal position is that a scheme under section 391 of the Companies Act does not have the effect of creating new debt. The scheme simply makes the original debt payable in a manner and to the extent provided for in the scheme. In the instant appeal, in most of the cases, the offence under the NI Act has been committed prior to the scheme. Therefore, the offence which has already been committed prior to the scheme does not get automatically compounded only as a result of the said scheme. Therefore, even by relying on the ratio of the aforesaid judgment, this court cannot accept the appellant's contention that the scheme under section 391 of the Companies Act will have the effect of automatically compounding the offence under the NI Act. The learned counsel for the appellants also relied on various other judgments to show the effect of the scheme under section 391 of the Companies Act. Reliance was placed on the decision of this court in the case of S.K. Gupta reported arrears. Stop.